who are unable to come into Boston and joining us via the internet for the webinar segment. Today, you have an opportunity to listen to panelists with substantial experience in acquiring companies in the government contracts and commercial space. You'll be able to ask questions concerning unique issues that arise in connection with acquisition of a government contractor. Due diligence in this government contract space is really a nuanced undertaking. It requires insight and experience of qualified practitioners with views into unique, practical, statutory, and regulatory challenges facing government contractors. Further, the due diligence issues that we are going to cover today, and others that time will not permit us to cover, are constantly evolving as the regulations and the statutes landscape change. Before I introduce each panelist, I'd like to say that when Pepper was looking to build a strong and vibrant Boston office and also expand its government contracts group, if we described the type of person and experience that we believe would enhance our firm's collective experience and be able to provide high quality and efficient counseling to Pepper's existing clients and prospective clients, our list would have included the gentleman that you are going to listen to today. With us today is Gary Campbell. He's a member of the Government Contracts Practice Group here in Boston, but he also works in D.C. as time permits and clients request. Prior to joining Pepper, he was an Associate General Counsel at GD Mission Systems. Gary has broad experience with large and small government contractors. He's counseled on a wide array of government contract-related issues, including M&A, due diligence reviews, contract negotiations, ethics and compliance, business disputes, protest claims, and international transactions, including the Foreign Corrupt Practices Act. Also with us is Matt Cole. He's a member of the Government Contracts Practice Group. He is in Washington, D.C. And Matt's experience spans the entire life cycle of government contracting, representing numerous companies in merger, acquisitions, and sales, involving complex due diligence reviews, detailed negotiations, and risk reduction issues in those transactions. Part of Matt's experience includes his time as Vice President and General Counsel of Micron PC Government, a top 5 GSA scheduled contractor with $500 million in annual sales. Last but not least, because I was doing this in alphabetical order, is Steve London. He's a member of our Corporate and Securities and Life Sciences groups. He's resident in Boston. For today's purposes, I wanted to just highlight some of Steve's experience, and that is concerning the M&A and transactions representing public and private equity and debt offerings, and venture capital financing. He represents emerging high-tech companies and publicly traded corporations and foreign companies entering the United States marketplace. I commend their full resumes to you. If you look at the last slide, you'll see a QR reader that you can scan with your phone, and the resumes will pop up, or you can go directly to the Pepper website. Our first speaker today is going to be Matt Cole.
Good morning, everybody. And before I start getting on the substance, I just encourage you one more time, if you have questions during the presentation, we love to be interrupted and address the questions as they come up. It seems to be more effective, in my experience, that way to do it. So for those of you on the phone and everybody here, just raise your hand or just flat out interrupt me, and it's good. My co-panels will certainly be doing the same, I have no doubt. So as part of the introduction, there's a healthy interest in government contractor M&A, and the reasons for that are varied, but it's certainly the fact that the commercial markets have improved but are still a little bit sluggish, and money is trying to find a place to go. You have some sexy niche plays within government contracts that can be fairly profitable. Things like homeland security, cybersecurity is all the rage these days. And then private equity has become much more of a participant in the government contractor market, particularly as the services contractors. In the past few years, they seem to have really cracked the code on that piece of it. So there's definitely, as you look at the surveys, government contractor M&A is one of the areas where there's been growth, and growth is forecast to continue. So let's talk a little bit about what do we mean by government contractors. There are different flavors. They're all covered by what we're going to be talking about today, at least in certain respects, but just to make sure we're all talking about the same thing, you have sort of these niche contractors that I mentioned, people like cybersecurity, which can often be small, 50, 100 employee firms, but have a very interesting business model and sometimes interesting technology. You have the traditional defense contractors, people like Raytheon, the USA Incs. Of the world. But then you also have commercial companies who just happen to have public sector customers. And so a company like Microsoft is not what any of us think of as a government contractor, but they have a multi-billion-dollar government contract business, and with that comes a lot of the same issues that somebody like Raytheon faces in terms of the regulatory regime that applies to their government contracts. Okay. All right, so still making sure everyone is on the same page as to what we're talking about. Our focus today is going to be on federal prime contractor issues. That being said, particularly as you think about the due diligence you're going to do, it's important to be aware that a lot of these same considerations flow down to entities that hold government subcontracts. And so the mere fact that you don't hold a government prime contract doesn't mean that none of this is relevant. In fact, quite a bit of it is relevant at the subcontractor level and needs to be given some level of attention. Now, there are of course, some issues that are either principally or only relevant at the prime contract level. One of these being, an example here is price reduction penalties under the Federal Supply Schedule Program, which are a big problem at the prime contractor level, doesn't even apply to subcontractors. So you want to be smart about it, but don't, and not focus on subcontractor issues that don't matter as you go through the due diligence assessment, but make sure that you're giving it due attention, focus. We are not going to speak today specifically about state and local government contracts. State and local government procurement rules tend to follow the federal model, although with probably it's fair to say less detail and much lower consequences for not doing it correctly. But keep in mind that there is at least some level of the same types of issues we're talking about that apply to a target's state and local government contracts. Those are regulated by state and local law to some extent. I'm going to get this eventually. Okay, so outline for what we're going to talk about today. We're going to give some background about the process itself to focus the issues that we're going to talk about to make sure they have a proper context. And we're going to lean on our partner, Steve, who's a pure corporate attorney and a lot smarter about corporate M&A issues and process than Gary and I, who are government contracts lawyers who just happen to participate in a fair amount of deal work. We're going to talk about the structures that purchases can have, and those you'll see as we get to it have some significant effect on both the approval process and the liabilities that the seller passes on to the buyer. The transaction structure, it obviously has important implications in areas like tax, but we're going to talk about strictly in the government contract context, how does the transaction structure affect the approval process and how you want to plan around that and be smart about how you structure your deals. We're going to talk about the Novation Agreement process. That's the process by which the government is required to approve a lot of government contract sales. And then we're going to get into the heart of the presentation, which is a checklist of 6 issues that are unique to government contractor M&A. And we tried to make it very practical. So for each of these 6 issues, we're going to give sort of a 2 or 3 minute nutshell summary. What is the issue? And then we're going to identify red flags that should alert a buyer during the diligence process that these issues might be in play. And then we'll conclude each of those with, all right, let's assume these issues are in play. What should you do as a result in terms of how you handle the diligence process, how you structure the definitive agreement itself, what, post-close integration issues that you want to be thinking about and have a plan in place for, rather than closing and then, sort of hit the scramble button at that point, which is something that happens not infrequently in our experience. And then the last point, we're going to go through the compliance risk and the extraordinary penalties that are attendant to government contract noncompliance. I've never thought it's really that useful to people in this context to spend an inordinate amount of time sort of walking through the parade of horribles that can happen if you don't do your government contracts correctly. But I do think that just sort of a baseline understanding of that is good to have, because not getting these issues right has consequences that flow well beyond what would happen if you were to basically screw up a commercial deal. I guess with the last point being this, the standard lawyer caveat that the issues we're going to talk about are the issues that we think are the most important government unique issues. There are others, things like classified contracts, and so we don't want to convey the impression that if you pay attention to these 6 issues, there's nothing else to worry about. But these are, 80-20 rule. These are the ones where I would spend most of my time thinking and focusing resources. So with that, I'm going to turn the microphone over briefly to Steve London, who's going to give us some context about the M&A process and the process for negotiating the definitive agreement.
Steve, before you start, I just want to let everybody know this slide, for whatever reason, is numbered 17. It should be number 5. So there's no, the mistake is on our end.
I wouldn't have seen that.
Nobody would have.
Thank you very much. It's good to be here, and as both Matt and Michael have said, I'm a deal guy. I run the M&A transactions from start to finish. We often need, as deal lawyers, experts in different areas of the law, and the government contracting team here at Pepper is integral to so many deals that we work on, because so many companies that are in the buying and selling scenario have government contracts of one kind or another. It may not be the big brand name government contractors that we all think about, but many of our clients have even one government contract, but that's enough to trigger the need for having experts as part of the transaction process. So we thought we would lay out first just the chronology, the kind of the life cycle of an M&A transaction. And we're talking here primarily about friendly acquisitions, negotiated transactions, and not public company hostile takeovers. That's a very different life cycle, very different process. So we'll confine ourselves to the negotiated friendly transaction. So at the start, there's conversations between buyer and seller about whether a combination might be interesting, valuable to both parties. If there is a sense of some future there, then the parties would typically enter into a confidentiality agreement that would then permit each side to share a lot more information, financial information, business information, strategic information that is part of the initial due diligence process. That's where you start the deep dive. As that dive is underway, the parties start thinking about the terms of a potential deal, and they start negotiating purchase price, payment terms, conditions to closing, some of the big picture items that are part of a transaction, and they will end up with either a letter of intent or a term sheet that lays out what those terms are. That's typically non-binding, except for just a couple of provisions, one being confidentiality, and two typically being an exclusive arrangement for a very limited period of time. But that's the document that you refer back to as saying, hey, we've got a handshake, this is what we think will turn out, subject to a bunch of conditions. And one of those conditions is the continued due diligence by the buyer to make sure that what they think they are buying is really what they will be getting. At the same time as that further diligence goes on post-signing of a letter of intent, the parties start negotiating definitive agreements. It's either a purchase agreement or merger agreement. It's the definitive agreement that lays out the details of the transaction. That gets signed, and it's very infrequent that there's both a signing and a closing at the same time. There's usually the signing, and then there are certain additional activities that need to be accomplished before the transaction closes, such as getting stockholder approval, third-party approvals, addressing government contracts that are in the portfolio, potentially satisfying other conditions to closing, which may be compliance with Hart-Scott-Rodino, antitrust notification. It may be the buyer securing adequate financing to fund the deal. There are a number of things that need to take place before the closing. Those get worked out. There's a closing, and then from the business standpoint, the really tough part happens then is the integration of the two businesses. Part of that integration process is the novation scenario with the government contracts, and I think we'll address that in a lot more detail later on. But that gives you just a kind of a context and overview of the life cycle, and you'll see how some of these subject matters that we'll be talking about later this morning fit into that timeline.
Okay.
Back to you.
I thought, okay, excellent. This is similar to what Steve was walking through. The process of due diligence is, am I really buying what I think I am? It's a chance to kick the tires, and to the extent that you find some issues with the car during that process, certain things can happen, such as a change to the purchase price, or even people just walking away from the deal entirely. This just isn't what we thought it was going to be. There's certainly there's a document review component to it, and we typically send out a customized but comprehensive list of documents that we want in the government contract space of it. So if we're acquiring a software firm and we're representing the buyer, we're going to have a different set of questions, a commercial software firm, than we are if we're buying a pure play defense contractor that has cost reimbursable contracts. Those are different sets of issues. And one thing I've found that sellers find really annoying is when they get sort of a kitchen sink type of approach to the document request, and you have to waste a bunch of time figuring out what's not relevant when you really kind of knew already what wasn't relevant. And so it's a better practice to send out a list that is customized to the circumstances. Is that fair?
It depends on who I'm representing at the time. If I'm representing the buyer, it's a very different dynamic. You want to make sure that you've asked all the possible questions. Yes, some may not be relevant, but we like to get not applicable as an answer so that we can make sure that there's nothing lurking behind the curtain that we weren't aware of. On the seller side, it's always this dynamic of, are you serious? Do you need us to answer all of these questions? Let's focus in on what's truly important. Let's be smart about this process and prioritize where the big risks are, and we'll address those.
Okay, that makes sense. And in addition to the document review, you're also going to have discussions with the seller's management and key employees. And some of these are going to be discussions about what does this document mean, what's going on with this, sort of fact inquiry. But there's also sort of an informal interview process quite often where you're figuring out as the buyer, who do I need to keep, who do I really need to keep, who do I not want to keep, and that's very much part of this process, although it can be fairly informal. And there's sort of an interesting dynamic, and I'd be interested in Steve's thoughts on this, but at some point during every deal, as you get closer to the deal closing, you can see the seller's employees kind of turning in terms of their, who they're catering to most, and particularly if they're interested in a role in the business afterwards, and they're not just agreeing to stay on for 6 months so things don't get a big mess. Where they're looking to have a substantive ongoing role with the buyer, you can sort of see almost visibly how employees turn in terms of who they cater to. But
it's primarily among top management, and if the C-level kind of employees have an expectation that they're going to move on with the buyer and stay with the buyer, there are mixed loyalties that occur very early on. And the board of directors of the seller needs to be very sensitive to that, especially in how the negotiations are led. So, for example, the CEO could be leading the charge of the seller on negotiating the transaction, but at a certain point, like Matt said, that CEO is going to be thinking about his or her employment agreement and his or her equity incentives with the buyer, and that changes someone's perspective on how they negotiate a deal. So the board of directors is where the ultimate responsibility lies to be sensitive to those potential conflicts.
And this is Gary Campbell. I just want to throw one thing in on diligence. Matt mentioned the interviews, and those are often overlooked when we think about the diligence. We think about that laundry list of items we're requesting. We're thinking about what's in the data room. But at some point, we're going to need to close this deal, and the buyer, leaning on its lawyers, is going to have to make a determination if they're comfortable, because you're going to run out of time to look at everything. You're going to make supplemental requests. You're always going to have supplemental requests, and you're going to run out. So you're going to need a level of comfort, and especially on some of the items I'm going to talk about later, that comfort, it may just come from that interview. Are you comfortable that there was a process in place that this target that we're talking to knows how to do government contracting? And as a real-life example, I was involved in, at the time, was the largest FCPA settlement. Now it's been blown away. Yeah, it's not in the top 10 anymore. Speaks to the enforcement actions and also my age. But and that all started with an interview during due diligence, and a manager of the target company gave a sarcastic response about, oh, we don't have any FCPA violations. And someone picked up, I wasn't in the interview, but someone picked up on it and asked a couple more questions, and next thing you know, it blew up the deal, and it was a $28 million settlement.
Question. I know this is more focused on buying, being a buyer in an M&A context, but when you represent the seller and you're helping them set up a data room for parties to look at, and they're a government contractor, your client is a government contractor, what advice do you give them? Do you, for example, questions like, do you put all of your contracts in the data room? These are very long and lengthy documents that might be in different places. Do you make them physically available? Do you not make them available at all? Do you require clearances?
Yeah, I mean, it's always a negotiation. I know as a buyer, I want to see everything. I'm going to want the whole contract. I want the whole file. Back in the day, it used to mean rolling in there and going through the file cabinets. Now, I don't remember the last time we did that. Usually we can get everything on the data room. But the clearances, export rules, there's a lot of reasons. So usually what we end up doing is there'll be not public, but there'll be some files that are available for everyone who has access to the data room, and then other restricted folders that might have your, anything that's ITAR controlled, and of course, anything that's classified, has to stay in the SCIF.
I'd like to just say one thing about the classified contracts. When it is a classified contract, they will not be put in any room. What is going to happen is you're going to have to get a deal with the target company that once the deal is signed or close to being signed, that there would be access to the classified contracts, and you would have to, as a buyer, you'd have to designate who is going to be the one who is going to look at those various contracts, and you also have to go to the customer and get their approval of this, because that's also a problem. And that's why I want to emphasize that these interviews are critical to know who you're dealing with, who actually has a good handle on the target's business, so that that will be an easier situation to navigate. And you want to have something in the transition in your transition agreement that says that the target will in fact assist in making sure that due diligence is done properly.
If I could add to that?
Yeah, if I could share just a couple of thoughts in response to the question. One thought is that there are, from time to time in a transaction from the seller standpoint, notwithstanding a very strong confidentiality agreement, you will have, whether it's a government contract or just a commercial contract, some very, very sensitive competitive information that you would be highly concerned about if the deal doesn't go through and now this buyer, who could be a competitor, has the information. Again, notwithstanding a strong confidentiality agreement. So we often have a handful of things that we don't disclose to the buyer in this diligence process. We tell them we're not disclosing it to them until we reach certain milestones. One may be that it is immediately before the signing of the merger agreement or right afterwards, and there's some conditions to the merger agreement that have that baked in. But it's worth thinking about from just a purely competitive standpoint. Are there things that could be put in the data room that once they are out, you really can't control? And it's okay not to put them in there as long as you tell the other side that this is a set of information that you will get later if we achieve certain benchmarks. So that's one thought. The other thought goes to the data room generally. And we talked about some interviews with key people. I'll relay one more story that shows the some of the risks of a data room. Is you can kind of get all sorts of a warm and comfort feeling by going through every single thing in the data room. But as an example, we purchased not that long ago a good old manufacturing business, old economy manufacturing business, and in that case, I was actually at the manufacturing facility in the Midwest, and it was a long negotiating day, and around lunchtime, I decided just to get some fresh air and walk around the facility outside. And in the backyard, it's obviously a big industrial backyard, were mounds and mounds of these barrels with all sorts of colorful things oozing out of them. And none of that was in the data room, but we saw it, and, you know, $2 million later after a cleanup and, you know, cutting off the purchase price because of that, the deal was done, but we would not have known that by just looking at the data room. So the data room can be a wonderful and efficient tool, but you also have to understand that touching, feeling, getting a sense from the people you're dealing with and the quality of the people and how they run their business is critical.
If I can ask a question, when we talked about people who transition from the seller to the buyer and the folks that go along, a lot of times there's major assumptions in the value of the deal that the buyer setting, the seller setting up, but they're transitioning, and after the fact, the assumptions are saying, hey, here's the high risk assumptions, and all of a sudden there's a dispute on the value of the deal. Have you been seeing that, a lot of purchase price disputes after these deals are happening? And if so, how do you recommend, with the transfer of people, how do you put a fence around that to limit that exposure?
The answer is yes, but where I see most of the disputes post-closing on valuation relate to purchase price adjustments on working capital issues. So lots of deals are done with a set purchase price, but post-closing, that purchase price is adjusted upward or downward depending upon the calculation of net working capital. And there are frequently issues about the determination of net working capital. The buyer always thinks it's lower than what the seller thought it would be, and it's often based upon accounting treatment, deferred revenue, recognizing revenue at different points. So that's where lots of disputes are. I see much less disputes over more defined benchmarks, such as a condition of the closing is that the CEO, the Chief Technology Officer, and one other person need to sign on as employees with a mutually acceptable employment agreement. If that doesn't happen, I don't see disputes about that. I see the deal's not getting done, but not a dispute over valuation.
Yeah, I was talking more about the working capital.
Yeah.
Because I've seen in our line the finance folks or the business making those assumptions for the portfolio and the business and what the valuation of the working capital is, and then they kind of switch allegiance because the deals happen, and you got a window to raise the dispute, and that's where I've seen a lot.
Yes, and we typically try to bake in a dispute resolution process that is hotly negotiated over how you resolve those disputes and what part of the dispute is actually subject to discussion. So yeah, there are issues on that frequently, and my advice on that is knowing that there are issues on that frequently, knowing that there are mixed allegiances. You've got to be really vet that estimated net working capital number pre-closing, not just by the internal CFO who may be moving on to the buyer, but by your outside folks to make sure. Also, vet the definition of net working capital and how it's calculated to make sure that's pretty precise, and then have a satisfactory dispute resolution process that will be relatively quick and not terribly costly.
One last point on the data room. One thing that we find, particularly with respect to smaller companies, they sometimes don't have the best handle on what government contracts they actually have. And so to avoid surprises, beyond just relying what's been given to you in the data room, there are now public databases that summarize government contract awards going back to 2007, 2008. And so part of the process now on the buyer side is to go out and run a report of what's available publicly, compare that to what's been provided, and see if there are any gaps. And it's frankly not at all unusual to find additional contracts, sometimes important ones, through that process, because a startup that's grown quickly does not necessarily have the type of professional, formal contract management organization that somebody like a Raytheon would have, where you could feel pretty good if they gave you the list of contracts for one of their business units, that it would be comprehensive. So with that, we'll move on to this next slide and just talk about how the government contracts fit into the reps and warranties piece of the sales agreement. You'll have seller reps and warranties in every sales agreement, something like no litigation except as disclosed in Schedule 23 or whatever the schedule is. Like you will with other regulated areas, you'll want specific reps and warranties as to government contracts. So something like no subpoenas or ongoing inspector general reviews or something to that effect. In addition to that, you're going to want to refine the warranties based on the information that you learn during the diligence process. And with the theory that the more precise the reps and warranties are, the more easily enforced they are. And so if you go through the process and you start to have some concerns that you can't effectively resolved to a point of 0 degree of risk, you'll get a rep. If, for instance, you're worried that the target has developed software that the government might have paid a portion of the development cost for and may be encumbered with government rights, you'll want to get a rep saying, government didn't pay for any part of the development of these crown IP jewels that I'm paying all this money for. So that's how that process works.
Could I just add one more thing? For the context, what are the purpose for the reps and warranties? Why are they there? There's 2 really main reasons. One is as part of the entire disclosure process, due diligence, and then committing to confirming that this is everything that you need to know about this company. But equally as important, if not more important, is the allocation of risk. What happens if it turns out that something that the seller says to the buyer is not true, whether intentionally or not? Who bears that risk? And so the reps and warranties then tie into other parts of the agreement that perhaps give the buyer a right to walk away if those reps and warranties are not true. It changes the purchase price through an indemnification or escrow process. So think about, in the bigger picture, we're just not writing down all of these government contracts because we want to. It's all about allocating the risk of the buyer's expectations not turning out to be correct.
Government contract reps and warranties, do you tend to see those survive longer than the general reps and warranties, assuming there's no specific issue that you discover in diligence, just generally? Would government contract reps survive for the same period as other reps and warranties, or would they tend survive for a longer period of time?
The answer to that depends quite often on leverage. You know, as buyer's counsel, we'll want to have a 6-year period if we can, because that's the statutory period for, you know, the parade of horribles, particularly the False Claims Act in terms of government. Right, that's, you know, difficult to accomplish quite often. And so sometimes you'll compromise and you'll add an extra year or 2 to what the standard duration is. And then if you find something during the diligence process, then you can sometimes have a further negotiation where you'll say, well, we need to extend the period of the escrow. A certain portion of the purchase price will go into escrow, or we'll reduce, and the seller may say, I'm not selling this business and I'm going to sit around for 6 years worrying about things, but I will reduce the price by a certain amount just to get it done. You've raised some questions. I don't think they're valid, but okay. And so it becomes a negotiation, but as a practical matter, as a buyer, you have to understand that there are long limitations periods for what these government contract specific reps and warranties get to. And so there's sort of a knowing assumption in most cases of a certain amount of risk for the period beyond the reps, beyond the duration you can get. But again, it's kind of a negotiation and a leverage issue. So.
Well, what I've seen on that is often related to deal size. I see an inverse relationship. The smaller the deal size, the longer the indemnity. The bigger the deal size, the shorter the indemnity. But there are other ways for buyer and seller to deal with this. Duration is one, but also in the indemnity, what's the cap on the indemnification, and what's the basket before you can hit the indemnity. So it's a number of moving parts that buyer and seller can maneuver to reach something that's mutually acceptable, depending upon the nature of the issue that you're addressing.
Okay, so just a quick summary of transaction structure that will lead us into a discussion of how this affects government contracts issues. There obviously, you can refine these to much, a large group of subsets, but you have an asset purchase agreement where the buyer will purchase some or all of the seller's assets. The buyer may assume some liabilities, may not. Separately, you can have stock purchase, so the buyer purchases the seller's stock. The corporate entity continues to exist in the same way with the same assets and liabilities, but its shareholders are different. And then you have a merger where you have a combination of firms. One survives and holds the assets and liabilities of both firms. The other one dissolves. And the merger is sort of an issue of great consternation to government contracting officers. They don't understand it. They don't really know what to do because in their head there should be two entities and suddenly there's only one. The statutes aren't directed toward mergers. We'll talk about those quickly. So fine to do a merger in a government contract context, but you need to understand that it may create some level of ongoing question and dialogue with customers. Okay. From a government contract perspective, asset purchase, pros and cons. It's great because the buyer gets to avoid assuming liabilities to some extent. It's not great in that you have to go through a novation approval process. We'll talk about some of the finer points of that. And there's also, as the seller and the buyer, you cross-guarantee each other's performance. So the buyer guarantees what the seller's done before, the seller guarantees what the buyer does in the future. That's an issue of some discomfort, depending on who the other party is. And it's clear that this cross-guarantee gets to garden variety things, like if you sold a warranty, as the seller, the buyer is going to have to honor that. And if the buyer sells a warranty later and doesn't honor it, the seller is going to have to come honor that. It's unclear legally whether extraordinary penalties like a False Claims Act case and damages, rather, would flow through a novation agreement. There's some dicta and a footnote in a appellate court case that says that it does not, but there's not really a definitive answer on that. Stock purchases are preferable in some contexts because no government approval is required, and the seller does not have to guarantee the buyer's future performance. So as a seller, sometimes it's very favorable because you just walk away. At that point, you don't have to give the novation guarantee. The con is the entity itself retains government contract liabilities, including penalties, after close. So if the seller has rung up a bunch of False Claims Act penalties during the time that it was running the company, the assets of that company are still available to satisfy the government's claim, for the duration of the statutory period. Merger, same as a stock purchase, but it really confuses the contracting officers within the federal government, and we'll talk about that in a second. It's important to understand the novation agreement process, because that's, if you're doing an asset purchase, you will have to do a novation agreement. If you're doing a merger, you might have to do one, and it has a real impact, particularly on post-close integration type issues, in addition to the sort of the carving up of liabilities that I've already talked about. So it's important to understand and plan for that. This novation concept comes out of statutes that date back to the Civil War, where people of influence would get large government contracts that they had no intention of performing and would often sell them off to parties that didn't know how to perform the contracts very well. And so there was a huge waste of taxpayer money. And so statutes were passed that said, you cannot transfer or sign a government contract without my permission. They actually said you can't transfer them, but the case law and the implementing regs are now written as you cannot transfer it without my permission. The vehicle for expressing permission is a novation agreement. It is attached to a contract modification, and once that modification is approved by the government contracting officer, the buyer is the successor, officially the successor contractor, in terms of in all respects, but certainly in terms of billing, collecting, the sort of the day-to-day stuff that's important to profitably running a government contract. There's a form agreement for this. It's part of the course materials that you'll receive. It's difficult to get the government to modify this form too much. or at all. In most cases, there's not much incentive for them to take the risk to modify it, and so just be mindful of that. What is the Novation Agreement? It's I mentioned, it's a three-party agreement. The buyer guarantees the seller's past performance, the seller guarantees the buyer's future performance, and in exchange for that, the government says, okay, I consent to the transfer.
The government actually requires a little due diligence, if you will, to say, okay, we agree to this Novation Agreement. We think these new folks, the buyers, are actually going to be able to perform and should be able to conform to the contract?
Yes, it's not unusual for the government to sort of kick the tires a little bit on the buyer. And in some cases, they just wave it through, but in other cases, they'll do a formal financial responsibility determination on the buyer. In fact, that's standard now for GSA schedule contracts. They have a center out in Kansas City, and every time you put a novation request in, the buyer has to send its financials out to Kansas City, and they take a look at it. Certainly in classified contracting, there's going to be some follow-up questioning. Cost reimbursable contracts, it becomes very relevant to the government what the buyer's overhead and G&A rates are and how that's going to affect what the government's paying for the contract that it awarded to the seller. And so there's definitely an element of that. And I think we'll get to it on the next slide, but it's often useful as the buyer, if you can, and sellers are often not crazy about telling their customers, hey, we're trying to sell our business. But for very critical contracts, it's often useful, if you can, as the buyer, to have an informal discussion with the contracting officer where you present a scenario of, okay, here's who we are. We're thinking about buying this business, and here's what it would look like. What are your thoughts on whether the government would be amenable to approving this? And in some cases, it's absolutely critical. I worked one deal where there was a large, you should call it a construction/energy firm up in Alaska that was on the road to being debarred, and they were selling their contracts to a large government contractor, and we didn't have any sense as the buyer whether the government would consent to the transfer of these contracts before or after the formal debarment happened. And so we went in and we sat down with the key contracting officers, and they all basically said, yeah, we know you guys. We'd love to have you in place with these guys because it'll be a lot more stable for us. And so we felt good about it, and the deal closed. And in most cases, novation agreements, they take 3, 4, 5 months or more. In this case, we got the novation agreements done in a week because they were so interested in, well, because they were afraid the debarment was going to come down and it was going to get taken out of their hands. And so we, that's definitely part of the process.
Could I ask you a question to maybe comment on the novation process and the transaction structure? In relation to the cross guarantees, if you have a merger, the entity, the seller is gone. It's out of existence. Stock purchase, the buyer owns the entity. Are you saying that there's going to be personal liability on the owners of that entity as the sellers for that cross guarantee, or where does that liability rest when the seller as an entity is gone?
Well, there's no novation agreement for stock purchases. There's no government permission required. For an asset purchase, it's the seller as a corporate entity that's on the hook for the guarantee.
But that entity could be dissolved the next day.
Absolutely. It's often a guarantee that's worth nothing.
Okay.
But if it's an ongoing entity that it's just selling off a business division, then that's a concern that they've guaranteed performance of somebody whose performance they have no control over. And then in the merger context, you can't submit a novation agreement until the deal is done. And so quite often you have GSA on a schedule contractor merger will say, I want my novation agreement even though it's a merger, and you'll say, well, but the entity doesn't exist anymore. And they'll say, I don't care. Are you not hearing me correctly? I want my novation agreement. And so what we tend to do in that context to make sure that we're not perceived as misleading, we put a recital in the beginning of the novation agreement form that describes what's happened in terms of the transaction, and then we give them their stupid novation agreement, and we move on and they move on. But that's what when I refer to the confusion attendant to mergers, that's what it is. Novation agreement, you don't have to do one for every contract. You get a lead agency, and they process and approve the novation agreement on behalf of the contracting officers for all of your government contracts, which are attached as a schedule to the novation agreement. They're supposed to go out and talk to the other contracting officers, get their input about whether to approve it or not. Sometimes they do that, and other times they just, as soon as their lawyer says the documents are ordered, they approve it, and the other contracting officers get notice when you send them the modification approving the novation agreement. There's some opportunity to form shop. 4212 tells you to use the administrative contracting officer for your largest contract. Sometimes it's not clear with indefinite quantity contracts which your largest contract is. And so if you have a contracting officer who is responsive and reasonable, quite often it makes sense to find a way to reasonably determine that's your largest contract and run it through her instead of the guy at VA that takes 6 months to process garden variety modifications. Practice tip, there are certain types of both contracts and even non-contracts, like a blanket purchase agreement that's just really a set of terms and conditions for future orders on an existing contract. It's good to list those in a schedule to the novation agreement because the contracting officers for those agreements often get confused about whether the novation approval scoops up their agreements or not. And sometimes they'll say things like, no, I think we're going to have to recompete your BPA because of this. If you can show them a modification that has their agreement on a schedule, that conversation gets a lot easier, and so that's a good practice to do that. And then we already talked about the pre-approval communications that make a lot of sense in some context if you can get it. This is the post-close piece that is really important to understand. You can't submit a novation agreement before you've got a signed transfer agreement, and it's going to take 2 to 6 months generally for that to be approved. So you have this gap in time where the seller is still the legal entity that holds the contract, but the buyer has purchased the contracts and often wants to begin performing these immediately prior to approval of the novation agreement. So you need to understand that there's this gap, and you need to structure your agreement around it so that you've got, the buyer is going to perform in the seller's name. That's perfectly permissible. You may have to get government approval for that, but they basically perform as a subcontractor in the prime's name. But you need to set the rules for how that's going to work. So things like payment, invoicing, communications with the customers can get really mucked up if you don't address that first. And you're also going to want to have a transition services agreement so that the functions the seller's employees have been performing, whether or not they become your employees, are handed off in an orderly fashion. So with that as context and background, we're going to get to the government unique issues that you want to pay really the most attention to in the context of government contractor M&A. The first of these is small business set-aside contracts. And these are contracts, the federal government has preference programs where they set aside certain requirements, certain government requirements, so that only small businesses can compete for these. And these can be, at a high level of small business, but there are various subsets of small business categories. Woman-owned small business, hub-zone small business, which is a distressed area where they're trying to incentivize economic investment. or a veteran-owned small business or a service-disabled veteran-owned small business where that status is critical to selling to the VA, for instance. The business's size is measured based on number of employees or average annual revenue, depending on the industry. It tends to be employees for manufacturing and revenue for services contractors. And the key concept here is that affiliates count when determining an affiliate's a defined term. We'll talk about it briefly. But if you are a subsidiary, a wholly owned subsidiary of another company, you are affiliated, and determining whether or not you're small, the calculation will include your parent's employees or revenue as applicable, which makes sense as you don't want, it's not consistent with the purpose of these programs to have somebody like Raytheon be able to set up a small business subsidiary by only putting 3 employees in it. Not to say it never had, let me be clear, I'm not talking about Raytheon, but not to say that never happened. But, all right, so obviously your status as a small business can change as a result of being acquired, and this becomes a real problem for private equity because you know, your typical mid to large size private equity firm will own a family of companies at all times, and because they are the majority owners of the entire family, that all gets aggregated, and so it's almost impossible for private equity to buy a small business and have it retain its status. So what happens? You lose your status as a result of an acquisition. The contracting officer might terminate the contract and recompete them. Doesn't usually happen, but it can happen. They may decline to exercise option years and recompete those. And you're certainly going to lose your ability going forward to compete for set-aside contracts. And that, you know, in some cases can be a big deal. For instance, if you were buying a small, a service-disabled veteran-owned small business, and their primary customer was VA, the loss of that status could really completely impair the value of that business. So there's now a rule that regardless of how the transaction is structured, it's on you within 30 days after close. If your status has changed as a result of an acquisition event, you have to proactively go and notify the contracting officer of this. In the past, you didn't have to do that for stock purchase, and so people were sometimes structuring their deals just to avoid that notice component. No way to avoid it now, and it's, you know, it's really important that you do that as well, or you get into kind of a fraud area. So. Red flags. Does the seller hold set-aside contracts? This shouldn't be that hard. If you look at the standard form 1449, it's the government contract cover sheet for commercial item contracts, block 10 tells you. They've got a box that checks that tells you, is it a set-aside contract or not? So it shouldn't be too hard to find. You can look in government databases. Are they representing themselves as a small business? That's another red flag. And you know, if these red flags are there and their status is either clearly going to be lost or at least at issue, you think about, you know, what value would you assign to that in terms of lost revenue under current contracts and lost ability to compete for new contracts.
Matt, have you seen a really downturn in the acquisition of small businesses? I mean, it's hard to, if the future revenue stream is greatly impacted, why would companies actually move forward with such a?
Well, some small businesses are not winning because they're set aside. They're winning because they got a really great technology or people, and so the loss of your ability to win, to compete for set aside business sometimes is a so what if the small business is you know, got a lot going on outside of just an ability to compete for set aside work. But it's definitely I mean, it's been an issue for a long time, so I don't think it's changed. But we've definitely gotten into some number of deals where partway through the process, mostly the private equity buyer, light bulb goes on, hey, we're not going to be able to run this as a small business. Maybe this doesn't make sense, or at least doesn't make sense under the terms we thought about.
And Matt, before we move on, we had a couple of questions coming in through the web. One is, what about when you're a subcontractor and the acquisition changes your size from a small business to a large business? How does that impact the deal? And actually, it's more of a statement in how the buyer needs to assess those in the recompetes. And I think the question there is, in addition to being unable to qualify for small business set-asides, there are a certain amount of contracts that may be awarded because of your status. Not that they're set aside, but every government contractor has a small business subcontracting plan that they need to have a good faith effort that they want to comply and they need to report on. So it is important to recognize a size change, even if that box on the 1449 isn't checked off, that a change in your status may affect your ability to may affect your future revenue. And then there's another question, does it matter whether the stock purchase is a public or private company? And I think this is with regard to novations.
Well, with a stock purchase, there wouldn't be a novation, and I'm not aware of, I mean, obviously you have some public company things to be concerned about, but in terms of the government approval process, I don't see any difference, based on whether you're publicly traded or not. It gets more complicated, the ownership issues in terms of determining whether you're a small business or not get very complicated if you're a publicly traded small company, because you've got this diffuse group of shareholders, and then you've got, we don't have time to get into that, but that's the only thing I can really think of that would be.
And then a final question is, even if not required, is it good business to request a novation agreement for your larger contracts?
I can't think of a great reason to do that as the buyer. I mean, if you want to get a seller guarantee, you can get that in your definitive agreement. And by avoiding the novation agreement process, you avoid that gap where, you're performing as the seller for 2, 4, 6 months. That's operationally is very clunky and not awesome.
I think customer communication and, letting your customer know what's going on and, getting their informal buy-in probably goes a long way with respect to your larger contracts, as opposed to getting bogged down with that novation process, if not required.
Agreed. I wasn't suggesting to be sneaky. It was more of a, just the mechanics get clunky.
Plus the fact that I used to represent government contracting officers when I was in the government. Contracting officers, they do not want the novation agreement. It doesn't matter whether a buyer or seller wants to do it. The government won't sign it. And if you think that getting a novation agreement when the government wants it, it takes a long time, it's going to take you forever for getting a novation agreement if they don't want it.
All right, so our checklist issue number 2, intellectual property rights, IP rights. Where the government pays you to develop something, they gain substantial use rights in that. And that can be an invention, so it could be patent rights, but it at least in our experience with M&A, is most often government data rights, which are rights in technical data or software. They both qualify as data. And, it makes sense. If the government pays you to develop a technical data package for retrofitting an F-15 cockpit, they want to be able to take that and use that next time to bid out the work so that it's as cheap and technically proficient a provider as you can get through competition, and not something where they've got to pay for it each time, or where the contractor then gets a corner on the market, and the government can only contract with this contractor because of the technical data that it owns, but the government paid him to develop. And so you need to be, very, very careful when you're assigning value to data that you understand the extent to which it's encumbered with government rights. Also, the contractor can own inventions and data, but there are certain notice requirements that they have to meet, or that can result in a loss of their exclusive ownership on the commercial side. And so some data has no application to the commercial side, and some inventions don't, but some do, and so it's important to understand that as well. Red flags, R&D contracts, those tend to be ones where the government they're paying you to do research, and so quite likely some IP is going to come out of that. If it's not developed exclusively at private expense, you want to look at, what are the government's rights in the IP? Is it important based on what you intend to do with the IP? Is it in some cases, it's really not that important because you're buying the data for its usefulness in the commercial market. Government's rights don't extend to the commercial market. It may not be a big deal, but it may be a really big deal. And so you want to understand that. Is it subject to the Freedom of Information Act? Did the government take the steps, or sorry, did the seller take the steps necessary to perfect its ownership in the IP for the commercial market? And if any of, depending on the answers to this, is the valuation that you assign to it different based on the encumbrances or questions about the contractor's perfection of its rights in the IP. So that's issue number 2.
Matt, could I interrupt on?
Yes.
Could you go back to the Freedom of Information Act? What is the likelihood that IP, that although owned by the government, the buyer still sees it as very valuable, but if it can be secured through FOIA, changes the dynamic?
It absolutely does, and that's why you want to figure out. There's an exemption, it's called Exemption B4 to FOIA, and that exempts confidential commercial or financial information and trade secrets. But if you've delivered the data to the government, it's in their possession, and if the government has rights in it, it's potentially subject to FOIA. And so now it may not be, it's a complicated inquiry, but it's something that you want to make sure, particularly, I mean, that's not really for software, but for technical data, you want to have a sense of whether it's exempt or not.
But, I mean, does that go to the markings that are required
Absolutely.
in the contract? So, I mean, that's part of where that comes in, I think, is the argument.
That is correct. A lot of it, was it properly marked when it was submitted to the government? And if it wasn't, is that a defect that can be cured now? So no, you're right, but that's what it gets to.
I think Dynacord had a recent case where their financial information was released because it was improperly marked. So that, I mean, that's one of the training lessons learned in some of the cases. IT.
Absolutely, yeah, because both your intellectual property and your at least very detailed financial information, not the contract price really, but information that's very granular financial information that's not public should be exempt from FOIA. But if you turn it over in a proposal and don't mark it, good luck. So, with that, I will turn the presentation over to Mr. Campbell for issue number 3.
Okay. The third issue we're talking about that is cost reimbursable contracts. And if you're acquiring a company with cost reimbursable contracts, you're acquiring a company that's subject to the most onerous regulations that the FAR has to offer. And if you're in the business of doing cost reimbursable contracts, that's, cost of your doing business, your compliance with those, you're familiar with it, it's built in, and you're still going to have issues that we're going to talk about. But if you are not familiar with it, then it's going to significantly change the way you do business. And it's going to be, frankly, a large cost to bring in the necessary experts to get a compliance system in place. The risk areas are both pre-award and post-award. Pre-award, when we're talking about pre-award pricing risk areas, we're talking about defective pricing, and that stems from inaccurate pricing. So every time you're submitting pricing to the government, you need to certify that it's current, accurate, and complete as required by the Truth in Negotiations Act, TINA. So if you're the buyer, you want to make sure your seller has a good TINA sweep policy in place. That what we talked about in the interview, they know how to collect their costs and they know how to report to the government. Post-award, the issues you're going to see, time charging and billing unallowable costs. As a cost reimbursable government contractor, much like the lawyers sitting around the table, they're filling out timesheets every day. As someone who did that, I found that they're very rigorous about getting them done. But if you're on site and every minute needs to be accounted for because it's charged to the government and you're not indirect, like the lawyers were where I work, you really need to be accountable for every minute, and those time charging issues come up frequently. And you just need to know that you're potentially buying that liability. Post-close performance and integration. If you have a G&A rate and you're buying a company with a different G&A rate, you need to figure out what's going to happen going forward. Perhaps you want to maintain a separate G&A rate, and now this is important, whether you maintain a separate legal entity or not, it doesn't need, you could integrate the acquisition into your company, be a single legal entity. If you so choose to set it up as a separate division on the books and have a separate G&A rate for it for competitive purposes, it's certainly allowed under the FAR cost principles and the cost accounting standards. There's a way to do it as far as allocating, the home office cost, but it's something that can be done, and it's something that you are going to want to figure out ahead of time how you want to treat it going forward. If, not always, but usually there's a difference between the G&A, it's a significant difference, something that's noticeable and impactful. Know that if your thought is not to maintain the separate rates, but you are looking to have a single rate, there may be limitations on those contracts that you're acquiring. If it's part of a novation process, the government may make a contingent upon it signing off on that novation that those contracts that you're acquiring are going to be capped. They're not going to get the benefit of that higher labor rate, the higher G&A rate that the acquiring company has. If you are not familiar with the cost reimbursable process and you're acquiring a company that's doing them, you are going to become intimately familiar with your DCAA and DCMA cognizant representatives. The enhanced audit rights that the government has is going to certainly a change, especially if you're a commercial company getting into the cost reimbursable contracting for the first time. Cost contracting rules and government audit rights may impede how you work with your recent purchase. If you're a fixed price contractor and you hire, you acquire a cost plus contract and you see a lot of synergy in what you can do for them, but you don't have a cost compliance system and they do, and maybe you can't do work for them, and as we said, until you make that investment and become cost compliant. And maybe that's something you don't want to do. Maybe you never want a DCAA auditor showing up to look at the larger company. So what are the red flags? How do I know what I'm getting into? You're going to see cost plus contracts. If they're R&D, they're most likely going to be cost plus contracts. If you're looking through the files, you see incurred cost submissions. You're going to see them. And the other red flag, it's not up there, but if you're acquiring a company that's doing some grant work, there's a good probability that those are cost plus as well. what do we need to do? Now, we see the red flags. What's our heightened due diligence on this issue? You've got to know what their TINA sweep policy is. Again, the interview is important. Make sure that the controller or whoever you're interviewing knows what it means to make current, accurate, and complete certifications. Need to know that they have an appropriate time charging procedure. They've probably had DCAA floor audits, asked for those floor checks. Audit reports of the incurred cost emissions. If you have a good floor check, you might not see anything, which is a good thing. So the lack of a floor check report isn't necessarily a red flag, but there will certainly be audit reports on the incurred cost emissions. Start talking about what you need to do post-close with the accounting system options, whether your system is adequate to handle the new company or not, and then vet out how you're going to work together in the future. The next issue that we want. Sure.
So, what's going on in the industry of DCA being so far behind with their incurred cost emission audits, right? And they're doing a transition, a carve-out from one business from another, but you have corporate expenses from the seller that were reimbursed by the government. How are companies handling in the transition agreement the document retention supporting future audits?
Well, that would be covered in the covenant, Steve?
Post-closing covenant.
Post-closing covenant. That you're agreeing to support any of those needs.
It's not going to be years out. So have we seen that in the industry? That's the issues, because my experience is now transition documents are lost. They can't support the cost, and DCA just question them because they don't have the ability. So how is that considered in the structuring of the deal?
I think it goes back to the discussion earlier with regard to leverage. As the buyer, you're certainly going to want the promises that it's going to be there, and you're going to want the shift in the risk if it's not going to be there, and there's any kind of reduction. But as you know, I mean, you mentioned how backed up DCA is. You're talking 6, 7, 8 years not out of the question, and what are the chances of you getting that kind of look back in your purchase agreement is unlikely. But it's just something to be very aware of, John, and make sure you are negotiating for it.
Yeah. In every deal, ultimately, you end up eating some risk that you'd rather not eat. But you just have to how large were the incurred cost emissions? Do you have any reason to doubt any of them? And if depending on how that turns out, a lot of times you just okay, all right, let's go forward.
You mentioned the capping on the rates. Is there ever kind of a reverse situation in the sense where even M&A might have, you're looking to get some synergies, right, and maybe reduce some costs? Has the government been aggressive in trying to kind of come back in and look at your cost structures and say, hey, listen, now that you're part of this bigger company, we can see that actually your overhead costs should go down. But as far as that is concerned, do you see that often, or is that a concern?
In case that wasn't picked up over the phone, the question is does the government ever come back and say, now that you're part of a larger company, your rates should be going down? And I think it does happen. I mean, it's not going to happen. There's a transition period for the integration. So in that period, it's not going to happen. But when, at the end of the day, your costs are your costs. But I think the government would expect to see reduced overheads when there's efficiencies. And frankly, that's part of what you're selling. That there are efficiencies with the integration. Okay, the fourth issue, federal supply schedule contracts. This is a huge issue as far as compliance It's always been a hot enforcement action with Inspector Generals and DOJ. And if you're acquiring, Matt gave a webinar, a great webinar last week on this topic. It's something we could talk days upon. His webinar is probably available on our website. If it's not there now, it will be shortly. So without covering everything that he did last week, if you're acquiring a company that has a federal supply schedule contract, and we'll skip the background of what that is, assuming everyone has it, high probability that there are issues there. For all the reasons Matt went over last week, and Matt and I have been at this a long time, unless it's really, I think, the VA and the GSA who administer their respective federal supply schedule contracts, they're really setting contractors up to fail by how those are currently structured. So unless you're getting sophisticated counsel in the beginning, there are going to be potential liabilities there. And we talk about going back to the interview. One of the questions I want to know is, did anyone help you get on your schedule? And if it's not, you know, a law firm or a consultant, or if it's the wrong consultant, perhaps, you know, then I'm not going to have a certain comfort level with that. Identifying, you know, early in the due diligence, you don't even need to wait to get in the data room to find out if they have a federal supply schedule contract. You can go to the GSA e-library and look them up. You know, you've got to know a little bit about their history in case they have different DBAs or prior companies. If they do hold the federal supply schedule contract, our heightened due diligence is going to include reward of their commercial sales practices disclosures. If it says we don't give any discounts, there's probably more questions you want to ask. You're going to want to look at their post-award price reductions. If you ask them what their basis of award customer is, if it says all commercial customers, there's probably going to be further issues. Are they paying their industrial funding fee? And it's not enough just to see their quarterly reports that they're paying this. You've got to understand what the process is. We had a client who their sales entry system couldn't identify. It was a commercial company doing government contracts, couldn't identify which ones were government contractors. So if you can't identify that and pay the appropriate industrial funding fee, chances are you're not going to be able to properly track the price reductions clause that's in the federal supply schedule. Country of origin rules, if you're supplying products, they all need to be compliant with the Trade Agreements Act. It's not a preference, it's a prohibition. You know, make sure that the company understands that there's a process in place so they know that they're not supplying anything out of compliance. It's been a hot enforcement area recently. And then good news, if you're supplying services, you don't have to worry about the Trade Agreements Act, but now you have to worry about your labor rate qualifications. And this is another area, you know, are they properly tracking what the federal supply schedule says? If I'm supplying a principal 3 at $200 an hour, it's going to have this requisite experience and this requisite education. How am I tracking that? How am I mapping that internally to make sure that's what I'm providing? I'm not providing anything else. You know, are you keeping the resume? Post-award, you know, while you have all these potential issues, it's also an opportunity. If you have a GSA schedule, your target has a GSA schedule, perhaps it's time to merge them. Perhaps it's a great opportunity to fix them if you don't like the way they're structured. It's, you know, perhaps you have a new business model going forward. So it's an opportunity to kind of freshen things up and move forward. Real life example of someone, you know, who got tripped up on this was Oracle's acquisition of PeopleSoft, and PeopleSoft had $100 million in liability resulting from its federal supply schedule. Real quick, as we're getting short on time, open proposals oftentimes get overlooked. We're worried about the contracts. We're going to ask what the proposals are. Maybe we're not looking at them. Maybe we're not thinking about them. If it's an important revenue stream for the acquisition and the value, certainly we're going to be looking at them. But there are other issues that can arise from these. there used to be bid protests. We all know the procurement process can be very long. These proposals can sit 6 months or longer, locked and change, including the company. The protests used to look at whether the entity that got the contract was the same legal entity that submitted the offer, and that would be a sustainable protest ground if it wasn't. There's a recent line of cases stemming from the SAIC-Leidos split where the legal entity stayed the same, but the corporation behind it changed. Their resources changed. So if they were relying on resources that's kind of stayed with the old SAIC, maybe they're not in the same position to perform the contract. So there was protests that were sustained based on that. Also, and I'll combine this with the next topic, the proposals out there may give rise to organizational conflicts of interest. We know what OCIs are. It gives someone an unfair competitive advantage. Examples are, I have either the same company or an affiliate company. We talked briefly about affiliates, where perhaps I'm making recommendations for what the government needs to purchase, and I have an affiliate company that's going to supply that. Perhaps I'm conducting, the obvious one, conducting procurements, anything like that. Look at those proposals as anything out there in the pipeline that's going to create an OCI either for the target company or once you are an affiliate. Things you see in the data room that so you ask questions about standing proposals, recently dated proposals, discussion letters with the government, and notice of intent. The final issue, OCIs, we talked about, we combined there. And just because it's important, I'll just take an extra 30 seconds in that, a sophisticated government contractor is going to know about OCIs, is going to have an OCI identification and mitigation process in place. But the idea of looking at what the value of this company is that you may be looking at, it has to take OCIs into consideration. Maybe the company is a competitor. Maybe the company is, you're looking to grow vertically. So if you're looking at a company you're not a competitor with, but you both are doing different aspects of the same program, OCIs have to be consideration. You don't want to cost yourself future business, especially to the extent that that impacts the valuation of the acquisition. To make sure that we comply with our law licensing requirements, we can't give a presentation without talking about the parade of horribles. But the real life example we just gave, the Oracle PeopleSoft, we've all seen it. It could lead to suspension, debarment, which is the death penalty for a government contractor. But really, what keeps us and in-house counsel up at night, the False Claims Act and the implications from that. So I know when I'm doing diligence, the two things, for the government contracts due diligence that we're doing is this going to affect the evaluation of the company? So we're talking about OCIs, we're talking about, am I losing small businesses? Is it affecting the evaluation? And the second thing is, am I buying any False Claims Act liability? All right, so we ran a couple minutes over, so I'm going to cut it off there.
Yeah, I think just real quick, we really appreciate everybody attending here, and we appreciate the folks online. And I know that we have some questions that we may not have gotten to online. We'll certainly get to you quickly on those. And for the people here, if there are questions you haven't had a chance to ask, we're happy to stick around the conference room for as long as you want to address anything that we haven't got a chance to. But thanks very much for your attention. Really appreciate it.
And let me just say that if you did not put your name and email address on a question, please email the question to us. More than happy to reply. We thank everybody for their attention, and those who came into Boston, we certainly appreciate you coming into the office. And if there are any questions or that are necessary that you feel that we you want it answered through this, please send them to us. Thank you again for coming.
Thanks, everyone. Thanks for the great questions, too.
Yeah.